Hello, I'm Bill O'Brien. I'm a intellectual property litigator who's been practicing in the field for over 25 years. My experience has included being a partner in a traditional intellectual property boutique, in a major 1,000 lawyer international law firm, and at my current firm, One LLP, which is about a 30 attorney intellectual property firm with offices in Beverly Hills, Newport Beach, and San Diego, California. My practice includes, as an important area, copyright litigation, but I also do patent litigation and trademark and trade secret litigation. And as somebody who practices in these different fields of intellectual property, one of the subjects that I find interesting is the division and boundaries between the different forms of intellectual property. Today I want to talk about an important recent Supreme Court case that has implications for those boundaries. And the presentation might be subtitled, "Be Careful What You Wish For," because a little bit more than a year ago, I suggested in an article that it might be time for the Supreme Court to clarify these boundaries, and specifically the scope of copyright protection for things like clothing, cars, and other products that are what the Copyright Act terms useful articles. One of the two cases on which I focused in that article was Varsity Brands versus Star Athletica, in which the Sixth Circuit had held that cheerleader uniform features like stripes and chevrons and color blocks could be identified separately from, and it could exist independently of, the utilitarian aspects of the uniforms, and were therefore protected by copyright. And the other case was a decision by the Ninth Circuit Court of Appeals that a car builder, by making a replica of the Batmobile, had infringed copyrights in a Batman movie and television show. In both cases, counsel for the losing defendants had filed petitions for writs of certiorari in January 2016, asking the Supreme Court to review the cases. And ultimately, the Supreme Court did not grant review of the case involving the Batmobile, but did grant review of the case involving the cheerleader uniforms, and has recently decided that case in a decision that has important implications for the future boundaries of copyright law with regard to useful objects. This area was one that had been characterized by a lot of uncertainty, resulting from, among other things, different views from different circuit courts about what the standard should be for when features of useful objects can be protected by copyright. The Sixth Circuit, in its decision in favor of Varsity Brands, had listed 9 different standards for when such features could be considered separable and thus copyrightable. And then, finding none of those standards satisfactory, the Sixth Circuit had created a 10th standard of its own devising. These competing standards included one from the Copyright Office, at least 5 from decisions of other circuit courts, and others from dissenting opinions and from intellectual property treatises. The Fourth Circuit called the issue a metaphysical quandary in one of its decisions, and Star Athletica, in seeking certiorari, called it the most vexing unresolved question in copyright law. So the Supreme Court granted certiorari to review the Sixth Circuit decision and, in its words, resolve widespread disagreement over the proper test for copyrights and features of useful articles. Now, an initial question might be, why are we even talking about copyrights in useful articles? We don't usually think of copyright as applying primarily to those sorts of products. I mean, people typically think of copyright as applying first and foremost to literary and artistic works. Many people know that copyright also applies to software, although it is not supposed to protect functional aspects of the software. But it can also apply to useful two-dimensional and three-dimensional objects. After all, the Copyright Act currently does provide for protection for what are called pictorial, graphical, and sculptural works. And if you think about a typical product, say a chair, it's a three-dimensional object with a physical shape. It has contours. It has colors. What separates it from a sculpture? Well, that's indeed one of the problems that the courts have been wrestling with. So why does this distinction matter? It matters because we have a range of intellectual property in this country, and different types of intellectual property have evolved over the years to have characteristics that it is hoped correspond to the needs of creators of these different types of products, and balance appropriately the need for incentivization of creativity against the need to permit competition. So the form of intellectual property that applies to a particular subject matter can make a tremendous, practical difference. The important practical differences prominently include just the length of protection, which varies tremendously. So a useful invention can be patented, and then that patent lasts for 20 years from filing of the original application. On the other hand, if it's a ornamental feature of a utilitarian object, that can be protected by a design patent, which lasts for 15 years from issuance. Copyrights have a much longer term. A copyright in a work by an individual author lasts for the author's life plus 70 years. For corporate authors, 95 years from publication or 120 years from creation, whichever ends first. So if a corporation can succeed in asserting copyright ownership over a design feature that otherwise would be considered to be protected by only a design patent, it can gain what amounts to a term extension of 80 years on its intellectual property rights and its ability to exclude competitors from using that design feature. So that's a huge difference, obviously. And if you can obtain trademark or trade dress protection for a product design feature, then you could extend the intellectual property rights potentially indefinitely. And in that context, the Supreme Court has shown sensitivity to the need to police the boundaries between different forms of intellectual property and to make sure that competition isn't stifled by permitting longer term or indefinite protection of features that more properly would be patented. For example, in the case traffics devices versus marketing display, the Supreme Court limited the ability of a patent owner to extend its ownership of a patented product design by claiming, well, that product had become associated as a source identifier of the product, and that therefore they should have ongoing trade dress rights following expiration of the patent. The Supreme Court said a utility patent is strong evidence that the features therein claimed are functional and therefore not copyright or not subject to trade dress protection. In Walmart stores versus Samara Brothers, the court further constrained the treatment of product designs as trade dress by saying that it could meet the requirement of being distinctive and therefore protectable as trade dress only on a showing of what's called secondary meaning, that the public actually has come to think of this as primarily an identifier of the source of the product rather than as the product itself. And the Supreme Court has shown in its cases that it supports a general principle that intellectual property owners shouldn't be able to get longer duration protection and stifle competition by recategorizing one form of intellectual property as another. So when I wrote my article last year, my thinking was that these two cases, the Towel Batmobile case and the Varsity Brands cheerleader uniform case, suggested that the time had come for the Supreme Court to step in to clarify the boundary between the lengthy protection available for copyrightable features and the much shorter protection, if any, that would be granted based on a utility or a design patent. So, what is the statutory statutory design under which useful article features can sometimes be protected by copyright? Well, if we go back over the history of the Copyright Act, originally such protection was not available. So in 1790, the original Copyright Act protected only maps, charts, and books. So only three examples of two-dimensional work. In 1870, Congress expanded copyright protection to so that for the first time it encompassed certain three-dimensional works of art. In 1909, the Copyright Act broadened protection for three-dimensional works. And over time, increasing copywriting of three-dimensional works has greatly increased the potential for encroachment of copyrights into the design of useful articles, which are mostly three-dimensional. So there have been issues in the past, of course, about what is a copyright-eligible work of art versus what's an uncopyrightable commercial, product. The Supreme Court long ago decided that something does not have to be artistic in the sense of having artistic merit as opposed to a commercial purpose in order to be copyrighted. For example, allowing copyrights of circus posters. The Bleestein versus Donaldson lithographing decision really put an end to attempts to limit copyright in commercial products as such, but the distinction still remained between copyrightable work and a three-dimensional useful object. This came up, interestingly, one of the contexts in which this came up repeatedly was in household lamps, because a lamp is obviously a useful object, a lighting device, but their stands and bases often are decorative. In a case called Rosenthal versus Stein, the plaintiffs had registered copyrights in statuettes, and then they put the statuettes into their lamp products. The defendant copied them and defended itself on the basis that when you combine a copyrightable object with a commercial useful product, the result is a useful product that can't be copyrighted. And in that case, the Ninth Circuit disagreed, saying that just because the defendant has put these things into a useful object doesn't mean that there isn't a valid copyright if they're infringing. The Supreme Court continued in essentially the same vein in the seminal case of Mazur versus Stein, where here again the plaintiffs had registered copyrights in statuettes, and here the plaintiff itself used the statuettes as lamp bases, and so did the defendants. The Supreme Court upheld the validity of copyrights, rejecting the argument that you can't protect artistic articles embodied or reproduced in manufactured articles. The court said that under the 1909 Copyright Act, Congress intended the scope of the copyright statute to include more than the traditional fine arts, and that there was nothing in the statute to support the argument that use or intended use in an industry of a otherwise copyrightable article barred or invalidated registration of the copyright. So this case law background was taken into account by Congress in adopting the current 1976 Copyright Act, which covers a wide variety of 2- and 3-dimensional original works of authorship. These include pictorial, graphic, and sculptural works. But there's a limit on copywriting of useful articles. And the statute defines a useful article as an article having an intrinsic utilitarian function that's not merely to portray the appearance of the article or convey information. And it further provides that an article that's normally part of a useful article is considered a useful article. The limitation that the court puts on has to do with the utilitarian aspects of the article, which is a concept that's not defined in the Copyright Act. The useful article provision says the design of a useful article shall be considered a pictorial, graphic, or sculptural work, and hence be copyrightable, only if and only to the extent that such design incorporates pictorial, graphic, or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. So they are separate, or at least can be identified separately from the utilitarian aspects of the article and are capable of existing independently of that article. Now, prior to the Supreme Court's recent decision in the Varsity Brands case, the courts, although they've disagreed on many aspects of the useful article restriction, have considered with fair unanimity, I believe, that there are two aspects to this separability provision with regard to features of useful articles: physical separability and conceptual separability. And in his dissent in the Varsity Brands case, Justice Breyer does a good job of illustrating those concepts. As an example of physical separability, Justice Breyer provides a picture of a lamp with a light fixture that's held on a brass rod that's inserted in a base. And then separately mounted on the base is a porcelain sculpture of a Siamese cat. He says, obviously the Siamese cat is physically separate from the lamp, as it could be easily be removed while leaving both the cat and the lamp intact. And assuming it otherwise qualifies, the designed cat, small sculpture of a cat, is eligible for copyright protection. So that's physical separability. And if somebody were to make a lamp copying the cat, that person would be infringing. For conceptual separability, Justice Breyer provides a picture of another lamp. Again, there's a cat, But now there's no separate brass rod holding up the light. Instead, the cat sits in the middle of the base, and the wires run up through the cat to the bulbs. So the cat is not physically separate from the lamp, as the reality of the lamp's construction is such that an effort to physically separate the cat and the lamp would destroy both. The two are integrated into a single functional object, and Justice Breyer compares that to the ballet dancer statuettes forming lamp bases in the Mazer versus Stein case. But that's an example of conceptual separability, because we can easily imagine the cat on its own, as Congress did in following Mazer versus Stein and conceptualizing the ballet dancer in that lamp. So the cat's conceptually separate from the utilitarian object that is the lamp. And again, someone who copied that cat sculpture would be liable for infringement. Now, to illustrate some of what's at stake in these issues over useful articles, and some other issues that might have been overtaken by the Varsity Brands decision, I want to talk a little bit about the case in which the Supreme Court did not grant certiorari, the case of DC Comics versus Towel, or at the Supreme Court it would have been Towel versus DC Comics. And this involved a man, Mark Towel, who designs custom cars. And he decided to make a replica of the Batmobile that was featured in the 1960s Batman television series. One can imagine poor Mr. Towel thinking about this. He's thinking, this is a car. It is protected, if at all, by a patent, and there was in fact a design patent on this Batmobile, but it's expired. So he's free to make his own copy, right? One can excuse him for thinking so, but when he got sued by DC Comics, it turned out otherwise. The Ninth Circuit's reasoning on this is very interesting. What the Ninth Circuit says is that the Batmobile is a character and protectable as such. The Ninth Circuit describes it as a crime-fighting car with sleek and powerful characteristics that allow Batman to maneuver quickly while he fights villains, and it always contains the most up-to-date weaponry and technology. That, to me, sounds a little bit more like a useful article, or even indeed a series of different useful articles than a character, but the Ninth Circuit thought otherwise, and also assumed without explanation that if the car is protectable as a character, it avoids the Copyright Act's restriction on copywriting useful articles. And I see nothing in the useful article provision that says that or would have that effect. So the statutory underpinnings for that assumption seem pretty questionable. And another questionable aspect of the decision is it really lumps together more than 100 different Batmobiles that have existed at different times with very widely different characteristics. Starting in the 30s, Batman drove a simple red convertible, and then he's had all kinds of different configurations of Batmobiles with all kinds of different capabilities. Are all of those really one character? The Batmobile case follows an earlier decision in which the Ninth Circuit decided that a car was a character. A car, I guess, was called Eleanor from the movie Gone in 60 Seconds. To me, it's basically just a yellow Ford that people drive around in different manners. But in the case of Athletica Films versus Sanderson Sales and Marketing, the Ninth Circuit held that too was potentially at least, eligible for copyright protection. All of this is particularly striking when we look back at the Ninth Circuit precedent from the 50s about characters being protected under copyright. In the case of Warner Brothers Pictures versus Columbia Broadcasting System, the Ninth Circuit held that the character of the detective Sam Spade from the book The Maltese Falcon was not distinct enough to warrant copyright protection, so somebody else could use that character in other works without infringing the copyright. Now, this was not specifically the Humphrey Bogart portrayal from the movie of the Maltese Falcon, but still it was a book largely about this character, and yet he's not considered distinct enough under supposedly still binding Ninth Circuit precedent, whereas a yellow Ford is distinctive enough to be protected as a character. So now turning to the case in which the Supreme Court has now weighed in on the test and scope of protection for features of useful articles under the Copyright Act, the Varsity Brands versus Star Athletica case, it provides a case study in how an aggressive manufacturer of useful articles can try to use the copyright law to hem in its competition, something that the case is likely to make more common in the future. Varsity Brands is a powerhouse of the cheerleading industry, and it has all kinds of activities relating to cheerleading, but makes, according to the press, most of its money in apparel. And it has been making more than $1.2 billion in sales. So it's a big company, and undoubtedly the 800-pound gorilla of the cheerleading industry. And part of its strategy for this dominance is apparently to pursue copyright protection. Varsity Brands companies have more than 200 copyright registrations for two-dimensional designs appearing on the surface of their uniforms and garments. And as described by Judge Thomas in the majority opinion in the Varsity Brands case, the design features are primarily combinations, positionings, and arrangements of elements that include chevrons, lines, curves, stripes, angles, diagonals, inverted chevrons, coloring, and shape. He calls them all surface decorations. Varsity Brands sued its competitor Star Athletica for infringing 5 of Varsity's registered copyrights. 3 of the registrations in suit are of drawings of cheerleader uniforms on outlines of human figures, and the other registrations are of photographs of cheerleader uniforms. Varsity contended that Star Athletica infringed those copyrights by copying, reproducing, displaying, and distributing infringing images of these designs in its 2010 catalog and its internet website, and by incorporating the designs onto the surface of Star's cheerleading uniforms. So Star Athletica was making cheerleading uniforms that the Varsity Brands contended were copies of the designs reflected in the registrations, and was also depicting such allegedly copied uniforms in its catalog and website. Star Athletica's defense was these were copyrights on cheerleader uniforms, and that cheerleading uniforms cannot be copyrighted because they're useful articles. So under the law that we've been discussing, the key point obviously is what are the utilitarian aspects of a cheerleading uniform, and are features that were allegedly copied by Star Athletica separable under the Copyright Act from those utilitarian aspects. And the two lower courts that approached this problem took dramatically different approaches to it. The district judge, Robert H. Cleland, took a literally Platonic approach, citing the philosopher Plato and talking about the ideal of a cheerleading uniform. According to Judge Cleland, the utilitarian function of a cheerleading uniform is not merely to clothe the body. It's to clothe the body in a way that evokes the concept of cheerleading. He felt that a cheerleading uniform loses its utilitarian function when it lacks all design and is merely a blank canvas without team colors, stripes, chevrons, and similar designs. He granted summary judgment to Star Athletica on the ground it's not possible to either physically or conceptually sever Varsity's designs from the utilitarian function of the resulting cheerleader uniforms. Now, this point was hotly contested by the parties. Star Athletica pointed to photographs of what cheerleading uniforms would look like, devoid of all decoration, and argued that they would resembled sackcloth, my word not theirs, but certainly not cheerleading uniforms. On the other hand, Varsity brands put forward photos of cheerleaders wearing plain white uniforms, and the U.S. government in its amicus brief to the Supreme Court reproduced a Norman Rockwell painting showing cheerleaders wearing fairly plain white uniforms. In any event, the Sixth Circuit Court of Appeal felt that the whole issue of kind of what the ideal or concept of a cheerleader uniform was not relevant. The majority of the Sixth Circuit panel denied that decoration or identification are utilitarian functions of clothing. Instead, the Sixth Circuit limited the intrinsic utilitarian function of cheerleading uniforms to just covering the body, wicking away moisture, and withstanding the rigors of athletic movements. And so whatever, chevrons and stripes and so forth were on the uniform had nothing to do with the utilitarian aspects as interpreted by the Sixth Circuit. In his majority opinion for the Supreme Court, Justice Thomas was joined by 4 other justices. He clearly strives to simplify the issues and hew closely to the statutory language of the Copyright Act. In his words, beginning and ending his inquiry with the text, giving each word its ordinary, contemporary, and common meaning. So it's largely a policy-free analysis from the point of view of Justice Thomas. He says this is not a free-ranging search for the best copyright policy, but rather depends solely on statutory interpretation. Doesn't seem to recognize there's a middle ground in which there could be less than free-ranging search and statutory interpretation that does take into account policy considerations. The one aspect of the legislative history that Justice Thomas does cite and take into account is that the 1976 Copyright Act's provisions on useful articles essentially track Mazer versus Stein and the Copyright Office regulation that had been designed to implement the Mazer decision. Thomas rejects some of Star Athletica's arguments as contradicting Mazer. And consistent with Mazer, he interprets the relevant statutes in a way that would afford copyright protection to the statuette and mazer, regardless of whether it was first created as a standalone sculptural work or as the base of the lamp. So what is the test that Justice Thomas comes up with, and joined by the majority of the court? He says, a feature of the design of a useful article is eligible for copyright if, when identified and imagined apart from the useful article, it would qualify as a pictorial, graphic, or sculptural work either on its own or when fixed in some other tangible medium. So Justice Thomas recognizes that this separability test adopted by the majority of the court amounts to a counterfactual hypothesis when applied to the features that originate as part of a useful article. He says the ultimate separability question then is whether the feature for which copyright protection is claimed would have been eligible for copyright protection as a pictorial, graphic, or sculptural work had it originally been fixed in some tangible medium other than a useful article before being applied to the useful article. Justice Thomas concludes in a fairly brief discussion that when he applies this standard to the specific copyrights at issue in the Varsity Brands versus Star Athletica case, they qualify, or they have features that qualify as separable from the utilitarian aspects so as to warrant copyright protection. He says, first, one can identify the decorations as features having pictorial, graphic, or sculptural qualities. Second, if the arrangement of colors, shapes, stripes, and chevrons on the surface of the cheerleading uniforms were separated from the uniform and applied in another medium, for example on a painter's canvas, they would qualify as two-dimensional works of art. Justice Breyer, joined by Justice Kennedy, dissents from the majority opinion. He would hold that Varsity Brands copyrights are invalid because they don't meet a proper separability standard. Justice Breyer's opinion, dissenting opinion, takes a very different approach from Justice Thomas's majority opinion. Unlike Justice Thomas, Justice Breyer discusses the legislative history in some detail. He cites statements in the legislative history suggesting that, generally speaking, useful articles like an automobile, airplane, ladies' dress, food processor, television set, or any other industrial product wouldn't be copyrighted. The list included ladies' dress, which is pretty similar to a cheerleader uniform in terms of suggesting what congressional intent would have been. He assesses the overall congressional intent behind the 1976 Copyright Act with regard to useful articles. He says it's clear that Congress has not extended broad copyright protection to the fashion design industry. And he also makes his own assessment of public policy considerations. He says that the fashion industry has thrived against this backdrop, and a decision by this court to grant protection to the design of a garment would grant the designer protection that Congress refused to provide. Justice Breyer, unlike Justice Thomas, reviews the available alternative forms of intellectual property. He says the cheerleader uniform, could be subject to patent design protection. if a clothing manufacturer has signature features that identify their products, it can obtain trademark protection under the Lanham Act. And he says a designer who creates an original textile design can receive copyright protection for that pattern. Typically, these have been a fabric pattern, in essence, that could be used, for example, for a curtain, for a dress, a distinctive repeating pattern, which is copyrighted separate from the garment or other product to which it might be applied. But these are not Justice Breyer's only reasons for rejecting the majority's test for separability. In Justice Breyer's view, it's unhelpful to focus on whether the design can be imagined as a 2- or 3-dimensional work of art. He says virtually any industrial design can be thought of separately as a work of art. What is there in the world, in Justice Breyer's words, that viewed through an aesthetic lens cannot be seen as a good, bad, or indifferent work of art? What design features could not be imaginatively reproduced on a painter's canvas? And Justice Breyer gives the example of a Van Gogh painting of shoes. He could also have referred to the a famous Parisian art exhibition in which a urinal was displayed as a sculpture. So what is Justice Breyer's proposed alternative? Instead of the majority's purely conceptual test, he would maintain a two-pronged standard addressing both physical and conceptual separability. He says the legislative history of the Copyright Act suggests two exercises, one physical, one mental. Can the design features, the picture, the graphic, the sculpture, be physically removed from the article and considered separately, all the while leaving the fully functioning utilitarian object in place? That physical separability. If not, can one nonetheless conceive of the design features separately without replicating a picture of the utilitarian object? If the answer to either of these questions is yes, then the design is eligible for copyright protection. Otherwise, it's not. Justice Breyer further explains his proposed test by saying, in many or most cases, to decide whether a design or an artistic feature of a useful article is conceptually separate from the article itself, it's enough to imagine the feature on its own and ask, have I created a picture of a useful article or a useful part of a useful article? If so, the design's not separable from the useful article. If not, it is. If extracting the claimed features would necessarily bring along the underlying useful article, the design is not separable from the useful article, in Justice Breyer's view. Now, how does he apply that to the cheerleader uniforms at issue in the Varsity Brands case? He says they certainly look like cheerleader uniforms. That is to say, they look like pictures of cheerleader uniforms, just like Van Gogh's old shoes look like shoes. I do not see how one could see them otherwise. Justice Breyer disagrees with Justice Thomas, saying that if he accepted the majority's invitation to imaginatively remove the chevrons and stripes as they are arranged on the neckline, waistline, sleeves, and skirt of each uniform and apply them on a painter's canvas, that painting would be of a cheerleader's dress. Now, there's another opinion in the case, an opinion by Justice Ginsburg alone, concurring in the result only, not the reasoning of the Thomas opinion. And she takes yet another very different approach. Justice Ginsburg doesn't see any need to address separability at all in the case. She insists that consideration of the separability test is unwarranted because the designs at issue are not designs of, her emphasis, useful articles. Instead, the designs are themselves copyrightable pictorial or graphic works reproduced on useful articles. As support for this conclusion, she notes that Varsity's designs first appeared as pictorial and graphic works that Varsity's design team sketched on paper. She appends to her opinion copies of Varsity certificates of copyright registration, which describe the works as two-dimensional artwork or as fabric design artwork. As a practical matter, I think they were doing that because if they put clothing on the copyright application, it would have been rejected by the court. Well, Justice Ginsburg's approach would certainly simplify analysis of the case, but it seems to me her argument proves far too much. She seemingly fails to consider that almost every useful article designed using standard commercial techniques originates as a sketch on paper or equivalently as a rendering on a computer screen. As a result, practically every design for a physical commercial product, whether clothing or cars, computers, or airplanes, could be submitted to the Copyright Office in the form of two-dimensional drawings. And in most cases, those drawings would have been created before the physical object was created. As Justice Ginsburg herself points out, the implications of her truncated analysis are sweeping. Because the owner of a copyright in a pre-existing pictorial, graphical, or sculptural work may exclude a would-be infringer from reproducing that work on a useful article, there's no need to engage in any separability inquiry to resolve the instant petition, she says. In other words, as long as a product design had been depicted in a sketch, she'd allow copyright ownership of that design as applied to useful articles without considering the separability of copyrightable design features from utilitarian aspects. But that would effectively nullify the statutory restriction on copyrights in useful articles. Everybody would just have to submit a sketch in order to obtain copyright on whatever useful article they pleased. Another debated issue in the Varsity Brands case is, did the majority apply its own new standard correctly? Writing for the majority, Justice Thomas considers the application of the test straightforward. He says, first, one can identify the decorations as features having pictorial, graphic, or sculptural qualities. Second, if the arrangement of colors, shapes, stripes, and chevrons on the surface of the cheerleading uniforms were separated from the uniform and applied in another medium, for example, on a painter's canvas, they would qualify as two-dimensional works of art. In his dissent, Justice Breyer insists the majority reached the wrong conclusion even under their own standard. According to Justice Breyer, were I to accept the majority's invitation to imaginatively remove the chevrons and stripes as they're arranged on the neckline, waistline, sleeves, and skirt of each uniform and apply them on a painter's canvas, that painting would be of a cheerleader's dress. Well, who's right? Justice Thomas doesn't explain or illustrate what the arrangement of colors, shapes, stripes, and chevrons on the surface of the cheerleading uniforms would look like on a painter's canvas. But one can imagine taking the basic shapes and spreading them out on a rectangular surface. If we did that, it's hard to see why Justice Thomas would necessarily be wrong in saying this painting would constitute a two-dimensional work of art eligible for copyright protection. Well, some people might find the chevrons and stripes reminiscent of a cheerleader's costume. It's dubious at best whether the painting would be of a cheerleader's dress, as Justice Breyer contends. It could also be regarded as merely an abstract arrangement of shapes. I suspect that many people would not even think of the idea that a cheerleading uniform could have similar shapes. As Justice Thomas notes, Justice Breyer's objection seems to rest on the argument that even when extracted from the useful article, the decorations on the cheerleader costumes would retain the outline of a cheerleading uniform. Justice Thomas responds, this isn't a bar to copyright, because just as two-dimensional fine art corresponds to the shape of the canvas on which it's applied, two-dimensional applied art correlates to the contours of the article on which it is applied. A fresco painted on a wall, ceiling, panel, or dome would not lose copyright protection, for example, simply because it was designed to track the dimensions of the surface on which it was painted. It seems to me that that's a valid point. And Justice Breyer's on even weaker grounds, I think, in insisting that considered on their own, the simple stripes are plainly unoriginal. That assertion that a pattern like this couldn't be original enough for copyright is hard to reconcile with widespread artistic acception of abstract and minimalist paintings that are even more simple than the design on these cheerleader uniforms. So whatever the merits of the alternative suggested by Justice Breyer and by Justice Ginsburg, the reality is that we are now governed, and will be for a long time, by the standard announced by Justice Thomas. So now that the majority has made its decision in Varsity Brands versus Star Athletica, where do we stand? What have we gained, and what have we lost, and what is likely to happen in the future in terms of copyrightability of useful articles? Well, there are certainly some advantages to the majority's approach. For one thing, we no longer have 10 different verbal formulations of standards for separability. For another, the majority's approach is simpler than many of the formulations that had been proposed earlier. The majority, for example, simplifies the standard for separability by eliminating the distinction between physical and conceptual separability. Justice Thomas says, the statutory text indicates that separability is a conceptual undertaking. Because separability does not require the underlying useful article to remain, the physical conceptual distinction is unnecessary. The decision by Justice Thomas also disclaims many of the factors that previous courts and the Copyright Office have considered, and that Star Athletica asserted should be considered important to deciding the utilitarian aspects of a useful article. The Copyright Office, for example, considered as part of its separability analysis what would remain after the copyrightable aspects, or allegedly copyrightable aspects, of the design were removed from the useful article. Under the Copyright Office's approach, conceptual separability could be satisfied only if two requirements were met. First, the items removed could exist as a fully realized artistic work, and secondly, the items that remained, or the characteristics that would remain after imaginatively removing the copyrightable features, would have to be a fully realized useful article. And the Supreme Court has rejected the second of those requirements. So again, the standard is simplified. One of the features that Star Athletica argued should be very important to determining what are the utilitarian and therefore uncopyrightable aspects of a useful article had to do with design considerations in creating the useful article. The argument that Star Athletica made was that to determine whether a feature is solely artistic and not utilitarian, you should consider whether the design element can be identified as reflecting the designer's artistic judgment exercised independently of functional influence. And that was also the position of the Seventh Circuit in a case called Pivot Point International versus Charlene Products. The example that is provided in Star Athletica's brief to illustrate why this is important is cases that have involved copyrightability of features of mannequins. How do you decide whether mannequin features are useful article or are how do you decide whether mannequin features are utilitarian or artistic? Well, one question is, in the design process, were they motivated by utilitarian considerations or solely artistic considerations? And the position of Star Athletica was, and also of the Seventh Circuit, was that they are non-utilitarian only if utilitarian considerations or functional influence really did not play a role in the creation of those features. Then, secondly, Star Athletica argued that great importance should be given to market considerations. Star Athletica, citing the Fifth Circuit decision in Galliano versus Harrah's, said that the court should evaluate whether there is a substantial likelihood that the pictorial, graphic, or sculptural feature would still be marketable to some significant segment of the community without its utilitarian function. In other words, without utilitarian function, does the feature still have significant market appeal simply because of its aesthetic qualities? In other words, without utilitarian function, does the feature still have significant market appeal simply because of its aesthetic qualities? And the argument by Star Athletica was that this indirectly measures whether the feature is a work of fine graphic or applied art, relying on the market and thus avoiding subjective decisions by judges. So, for example, applying this test to a mannequin, one could ask, would there be any kind of a market for this mannequin as an artistic work, or would interest in it be solely limited to providing a structure on which to put wigs, clothing, or other, products for sales display? But Justice Thomas rejects consideration of either of those two factors, design considerations or marketing considerations. He says neither consideration is grounded in the text of the statute. The statute's text makes clear that our inquiry is limited to how the article and feature are perceived, not how or why they were designed, and the same is true of marketability. I'm not sure why Justice Thomas feels confident that utilitarian aspects, as cited in the statute, cannot implicate design or marketing considerations. But he is, and that is now the law. So the Supreme Court has simplified the issues about the verbal formulation of the standard for copyright protection of useful articles, and has simplified what factors need to be taken into account. But besides simplifying the legal analysis in those ways, has the Supreme Court really clarified which features of useful articles a court should deem to be copyrightable and which it should deem to be non-copyrightable? Or is the Supreme Court's new simpler standard even less predictable in its outcomes than even the plethora of competing circuit court standards that the Supreme Court has swept away? The answer to that question will emerge over time as new cases are decided. But my prediction is that we'll see increased uncertainty and potentially a major expansion of copyright litigation as creative lawyers try to apply copyrights to a greatly increased number of features of useful articles. I also predict that there's likely to be a significant increase in the number of copyright registrations filed for useful articles, or more strictly speaking, depictions of useful articles, if there's any possibility that features a competitor might want to use might be deemed to be conceptually separable from the utilitarian aspects of the design, then why not take photos of any product that you have that has commercial value, or submit the design drawings of those products for registration at the Copyright Office. At the same time, you might file a design patent or utility patent application under conventional practice. The court's new test posits a nebulous question of what can be identified and imagined apart from the useful article. The application of that kind of a standard is debatable in practice, as illustrated by this very case. Neither the Supreme Court's majority nor its dissent have succeeded in formulating a test that fully accomplishes the result they assert. To the extent that the outcome of the majority's test is predictable, it would only be because being required merely to imagine a feature apart from a useful article fails to provide a significant barrier to encroachment of copyrights into the design of useful articles. Also noteworthy in the decision is the majority's lack of interest in addressing public policy concerns, such as the appropriate allocation of subject matter between different forms of intellectual property. If lower courts follow a similar approach and don't worry about whether a particular feature ought to be or would conventionally be protected for a shorter term of years under a utility or design patent, the likely effect is expansion of copyright protection. All in all, despite the Supreme Court's efforts at clarification, the law in this area remains underdeveloped and potentially troublesome. So in the future, now that we have this decision, are there safe harbors? Places where the copyright law clearly can't go? Well, while Justice Thomas's opinion is logical and internally consistent, his analysis points up the lack of clear limits on how far imagination can carry us in creating copyright protection for features that ordinarily would be considered part of a useful article, but could be imagined, arguably, to be depicted in as a two-dimensional, drawing or painting, or on some three-dimensional object other than the useful article. The majority opinion acknowledges several limiting principles, but it's unclear how limiting any of them is really likely to be in practice. For example, Justice Thomas writes, to qualify as a pictorial, graphic, or sculptural work on its own, the feature cannot itself be a useful article or an article that's normally part of a useful article. He adds, respondents have no right to prohibit any person from manufacturing a cheerleading uniform of identical shape, cut, and dimensions to the ones on which the decorations in this case appear. Those statements leave open, however, the extent to which features can be parsed and imaginatively reworked as part of the process of conceptually separating them. Well, the majority opinion specifies that the only feature of the cheerleading uniform eligible for copyright in this case is the two-dimensional work of art fixed in the tangible medium of the uniform fabric. There's nothing in the majority standard to exclude copyrights in three-dimensional features that can be conceptually separated from a useful article. And it's not clear what the limits on such conceptual separation will be. Justice Breyer tries to find an important limiting principle within the majority's opinion, where it states that one may not claim a copyright in a useful article merely by creating a replica of that article in some other medium. But he concludes the majority's lost sight of that principle in upholding Varsity Brand's copyright claim. Whoever is correct about it, that the majority statement can't be relied upon as providing clear protection against copyright infringement liability. For example, as I mentioned earlier, it's likely to be the case in the majority of instances that a depiction could be created prior even to the creation of the useful article. So there's not likely to be significant protection from other copyright law concepts, such as the creativity requirement for copyright. The Supreme Court has said that a work of authorship must possess some minimal degree of creativity to sustain a copyright claim, but the key word there is minimal. The Supreme Court has also said the requisite level of creativity is extremely low. So it is very difficult to pick any feature if you have, say, a copyright registration on a photograph of a useful object and say, oh no, that is too trivial, not sufficiently creative, that if we have that feature, we could be accused of infringement. The Copyright Office has denied registration to some very simple designs. For example, simple diamond stud earrings, hoop earrings, and other jewelry designs that contain only a trivial amount of authorship, or just touching up an aged or damaged photograph to restore it to its original condition. But the vast majority of situations in which really anything has been submitted for copyright protection, it's been found that the minimal creativity standard has been met. Similarly, the fair use rules in copyright are not likely to provide much protection in this context. For example, the first of the statutory fair use factors is the purpose and character of the use, including whether it's of a commercial nature. The type of activity that we are talking about here usually will be of a commercial nature. Mattel's selling a Batmobile, Star Athletica selling cheerleading uniforms. And the fourth, and often the most important factor, is the effect of the use upon the potential market for or value of the copyrighted work. And this type of copyright on features of useful articles is most important precisely because of its competitive impact, providing a barrier against competition. So typically in the cases where this concept of copyrighting useful article features is going to have the most bite, there's not going to be fair use because the copyright in question is protecting a potential market. One question that I think is raised both by the majority opinion and by Justice Breyer's dissent is whether there's a new issue lurking in the useful article doctrine that is likely to emerge at some point. The way I see it, it's really necessary to think about this in order to try to fully make sense of both Justice Thomas and Justice Breyer's opinions. The issue in Star Athletica was framed by the litigants as the validity of Varsity Brand's copyrights. But is there another issue lurking without explicit recognition? Specifically, is it possible that the Copyright Act's limitation on when the design of a useful article shall be considered a pictorial, graphic, or sculptural work applies not only in analyzing the validity of the copyright, but also in analyzing whether the design of the useful article infringes a copyright? So, does that limitation requiring separability applies when you're looking at infringement as well as validity? I think there are suggestions of this in both the majority and the dissenting opinions. For example, Justice Breyer says that Van Gogh's painting of a pair of old shoes, although beautifully executed and copyrightable as a painting, would not qualify for a shoe design copyright. Justice Thomas makes an analogous comment about a hypothetical cardboard replica of a car, saying that although the replica could itself be copyrightable, it would not give rise to any rights in the useful article that inspired it. And he makes another such comment in attempting to refute Justice Breyer's suggestion that a shovel could be copyrighted under the majority's test for separability. Well, is that true? Justice Thomas responds, a drawing of a shovel could of course be copyrighted. And if the shovel included any artistic features that could be perceived as art apart from the shovel, and which would qualify as a protectable pictorial, graphic, or sculptural work on their own or in another medium, they too could be copyrighted. But a shovel as a shovel cannot. Now, one thing all these statements I've quoted from Justice Breyer and Justice Thomas have in common is that taken literally, they don't comport with presently recognized copyright law. The key principle is that copyrights in any form of a copyrightable work are infringed when that work is reproduced in any form whatsoever, whether in the same medium as the original or a different one. So under existing law, there's no such thing as a copyright that applies to a painting, a drawing, or a cardboard replica, but not to reproduction of those works as part of useful articles. And this was discussed, for example, in the briefs. The amicus brief filed by the U.S. government gives some interesting examples. So, for example, if you took the Van Gogh painting Starry Night and made a fabric that had that image in it, and then made that into a dress, if there still was an operable copyright in Starry Night, that dress would infringe. It doesn't matter that Van Gogh hypothetically might have registered a painting when it comes to the infringement side, and you're asked, well, is it infringement of what you might loosely call a painting copyright for somebody to put that on a dress? It's infringement for them to put it on a dress, put it on a sculpture, put it on a doll, or anything else under present law. So another example the government gives is a Klimt painting in which a woman is wearing a distinctive dress, and the woman in gold, and the point is the same there, that if you made a real dress or a doll dress matching the dress worn by the woman in the painting, the fact that Klimt had hypothetically registered a painting for a copyright wouldn't limit his ability to pursue copyright infringement against the maker of the dress. So there's no such thing under the current case law as a shoes that are copyrightable as a painting but not as a shoe design. True, you can't file an application for a shoe design copyright, but you can file an application for a painting or a photograph, and then if somebody copies that on shoes, that would be infringement. So maybe Justice Thomas and Justice Breyer are both suggesting that that might change to a certain extent. The most logical way to implement the results called for by both the majority and the Justice Breyer dissenting in Star Athletica might be to revisit the issue of what it means to say that the design of a useful article can be considered a pictorial, graphic, or sculptural work, and look at whether, in analyzing infringement, you cannot consider the design used by the alleged infringer to be a pictorial, graphic, or sculptural work and therefore an infringing copy, if it doesn't meet the separability requirement of the Copyright Act. We'll have to wait for new cases to see if anyone raises those issues, and if so, whether the court is as favorably disposed to them as I believe the logic of this decision suggests they should be. So I hope this discussion of this important new case has been helpful to you. Again, I'm Bill O'Brien of One LLP. I can be reached at WOBRIEN@onellp.com, and I am happy to talk with my fellow intellectual property practitioners about this talk I've just given or any of the issues I've been discussing.